Welcome to the latest iteration of the National Prison Debate League, where we're all about decarcerating minds. We're excited to bring you a dynamic policy debate about cash bail from our team in Connecticut, from True Debate, hosting the amazing team from New York, came from New York, Binghamton University, to join Cheshire on site. And we're very excited to just thank everyone who's worked with us so hard to make this happen. Specifically, want to acknowledge Councilor Pacheco, Captain Quinn, Lieutenant Vassar, Councilor Jones, our community partners in action, always supporting Connecticut's NPDL teams by providing the fresh new gear that they're rocking right now. Every semester, just doing everything we can to resource and equip our team. So we really thank our community partners. We also want to thank Connecticut's own NPDL research assistants from Wesleyan CPE, Troy Grant. And we also have Clyde Meckel joining, and they've been such great additions to the Connecticut team this year and assisting the team. Also, really, we just want to thank everyone who's tuning in from all over the world tonight on this Zoom webinar, because this is what decarcerating minds in action looks like. And my name is Daniel T.R.U.E. I'm the founder and executive director of the National Prison Debate League. And I'm really proud to be able to see the growth that we have. And also want to thank our friends, because not only do I work with the National Prison Debate League, I'm also an organizer for the Massachusetts Bail Fund. And I want to shout out the National Bail Fund Network and all of our comrades around the country who are doing abolitionist reform work. And we look forward to really hearing these arguments tonight. To lead us through tonight's program is our assistant director and your moderator, Connecticut's own Miss Brittany Lamar. Brittany?
All right. Good evening, friends, supporters, honored guests. You're all about to witness an unforgettable display of both intellectual ability and social diplomacy in action as our teams from Binghamton University and True Debate convene for a policy debate on the following topic. Resolved, the United States should abolish cash bail. True, coached by John Katsoulis, Director of Debate at Boston College, and Ed Panetta, Director of Debate from the University of Georgia, will argue in the affirmative, supporting this resolution, while Binghamton University, coached by Joe Schatz, argues in the negative position, refuting the affirmative's case. Each debater will be judged upon the following criteria: analysis, reasoning, evidence, organization, refutation, and delivery. The three very distinguished judges of today's debate are Chief Judge Rita Rosenthal, the Director of Public Speaking at Boston College, Will Shanahan, professor at Curry College and former director of debate at Fort Hayes, and Dom Cameretta, who is the CFO of the Cameretta Group. As today's moderator, I will introduce our debaters individually, and they will adhere to their specified time limits. A digital timer will be displayed on screen, and speakers' microphones will be muted if they exceed their time limits. At the conclusion of the debate, our judges will tally up each team's cumulative point totals to determine the winner of today's contest. With all of that said, it's now time to start this debate. Presenting the affirmative team's first constructive argument for 7 to 9 minutes is Jeremy McGowan. Jeremy is currently a junior mentor with the T.R.U.E unit, takes college classes through the CPE program facilitated by Wesleyan University, and hopes to continue his educational journey upon release.
Good evening, honorable judges and esteemed opponents. My name is Jeremy McGowan, and today my cohort and I are here to affirm the resolution. Resolved, the United States should abolish cash bail. Cash bail is a system whereby an individual who has been arrested is required to post a monetary sum with the court before being released prior to their trial. Most often, a judge determines the amount of the bail in a very brief hearing. If an individual is unable to post bail, they are locked up in a jail until their trial begins. If a defendant does not appear for their trial, they forfeit their entire bail amount. This financial penalty, it is claimed by advocates of cash bail, is needed to deter defendants from fleeing and committing additional crimes. However, this rationale is flawed, and we will demonstrate in 3 contentions that cash bail is unnecessary, profoundly unfair, harmful to individuals, and imperils public safety. We begin with contention 1. Cash bail results in the jailing of hundreds of thousands of individuals every day. Since 1970, jail populations have skyrocketed in the United States. Bill Leitner reported in the Detroit Free Press on November 15, 2024, that jail populations, quote, rose more than 400%, while the nation's population went up only 70%, end quote. This increase in jail populations is a direct result of cash bail policies needlessly incarcerating low-level offenders who are too poor to pay their bail. Nicole Manzano of the Bail Project stated in 2023 that, quote, on any given day, nearly 500,000 people languish in jail cells across the country waiting for their cases to move forward, end quote. And on average, during any year, Jacqueline John of Drexel University School of Public Health observed in 2024 that 7.2 million people are incarcerated in pretrial detention jails for an average of 26 days. The harms that cash bail causes to individuals and communities are next explored in Contention 2. Cash bail harms individuals and society. The harms promoted by the cash bail system are widespread and pernicious. We will isolate 5 independent harms. First, cash bail undermines the presumption of innocence, which is a core tenet of our criminal justice system. The whole idea behind the presumption of innocence is that one should not be punished for a crime until one is convicted, innocent until proven guilty. I'm sure everyone has heard that before, but it seems that the idea of innocence is erased as soon as the defendant is handcuffed. Cash bail undermines the presumption of innocence in 2 ways. First, it promotes the mass incarceration of individuals who have not been convicted of a crime. Ali Preston of the Center for American Progress noted in 2023 that more than 80% of people in U.S. jail cells have not been convicted of a crime. Therefore, Preston argues, incarcerating them is imposing a punishment before they have been convicted, which is contrary to the presumption of innocence. Cash bail practices also undermine the presumption of innocence, Preston argues, by compelling, quote, people to take plea deals regardless of their guilt or innocence in order to secure the release from jail, end quote. This is a widespread outcome. Andrew Larson, the editor of the Vermont Law Review, argued in 2024 that, quote, many defendants awaiting trial pled guilty in plea arrangements irrespective of their culpability in an alleged offense because they are desperate to get out of jail, end quote. Of course, accepting a plea deal earns someone a criminal record, which creates barriers to accessing public housing and gaining a job. Eroding the presumption of innocence harms respect for the rule of law and our justice system. Frank Fernandez, a criminal defense lawyer, observed in 2023, quote, innocent until proven guilty ensures that each member of society receives equal treatment under the law and creates trust within our judicial systems, guaranteeing justice based solely on facts rather than assumptions or biases, end quote. A second harm to cash bail is that it creates a 2-tiered system of justice in which people of means can immediately get released back into the community, whereas people who are poor are forced to languish in jails. This is a grossly unfair and immoral system of justice. Ending wealth-based detention is a vital step toward achieving the goal of equal justice under the law for all. David Gaspar, the CEO of the Bail Project, observes, quote, justice should not be for sale. It must be equal for all, end quote. A third harm to cash bail is that it confines hundreds of thousands to reside in horrendous and dangerous jails. This can be extremely harmful to one's physical and mental health. A 2022 report from the Center for American Progress put out some facts that highlight the grim realities. The leading cause of death throughout jails is suicide, with pretrial detainees being 6 times more likely than their convicted counterparts to die from suicide. 1 in 30 people report experiencing sexual assault while incarcerated. People in jails have 4 to 6 times higher rates of mental illness than the overall population. A fourth harm to cash bail is that it destroys the economic livelihood of individuals, which leads to poverty and recidivism. Studies indicate that pretrial incarceration causes people to lose their jobs and earn lower wages. Andrew Larson, the editor of the Vermont Law Review, stated in 2024 that spending just 2 days in jail reduces someone's, quote, economic viability, induces recidivism, and creates health risks, end quote. The former Arizona Chief Justice Scott Bales declared that, quote, fines, fees, and bail not only can contribute to cycles of poverty, they can contribute to cycles of criminalization, end quote. In fact, studies show that pretrial incarceration increases the recidivism rate by 6 to 9%, according to a 2023 report by the Center for American Progress. A fifth harm to cash bail is that it imposes massive financial costs. Factoring in the direct costs of incarceration, along with the indirect costs of pretrial detention due to increased use of homeless shelters, public assistance, and public defenders, the American Center for Progress estimates the cost of cash bail amount to $140 billion per year. All 5 of these harms would be avoided if cash bail were eliminated, as we demonstrate in Contention 3. Eliminating cash bail solves. In September 2023, Illinois enacted the Pretrial Fairness Act, becoming the first and only state to ban cash bail. Under this law, any individual arrested for a misdemeanor or low-level felony is automatically released back into the community. When their trial date is determined, the individual is notified by the court to return for the adjudication of their case. For the serious crimes where an individual is eligible for detention, the PFA mandates a hearing before a judge. Prior to the hearing, a public safety assessment report is prepared and provided to the judge, assessing the flight risk and potential dangerousness of the person. In an adversarial hearing, the prosecutor and defense attorneys make arguments before the judge as to why the person should or should not be confined to pretrial detention. After a year of implementation, the empirical evidence demonstrates the PFA has been a resounding success. The number of persons being held in pretrial detention has significantly declined. According to the Nation magazine of December 2nd, 2024, a Loyola University of Chicago study examining 89 counties found that the jail populations had declined in urban areas by 14% and by 25% in rural areas. The fear that eliminating cash bail would increase the risk of crime and flight risk has also been disproven. John Clark, a WTVO reporter, noted on September 13, 2024, that a report by the Center for Criminal Justice at Loyola University found that following the enactment of the PFA, there was a 12% decline in violent and property crime, and the failure to appear rate decreased from 17 to 15%. The positive results reported in Illinois are not an aberration. In fact, every academic study has concluded that eliminating cash bail improves public safety. Phil Mayer, senior staff attorney at the ACLU of Michigan, stated in the Detroit Free Press on November 15, 2024, quote, "Everywhere that studies have been done, they found that there's no impact on public safety from eliminating cash bail, or public safety even improves. Because when you throw someone in jail for a lack of $300, they may lose their job, they may lose their housing by missing a rent payment, and in the long run, they may go back to committing crimes," end quote. In 2024, the Brennan Center released the results of the most comprehensive study ever conducted on bail reform. They examined evidence from 33 different cities and analyzed monthly crime data from 2015 to 2021. They compared crime statistics for murder, assault, burglary, car theft, and larceny from cities that had enacted bail reform to those that had no reform. The Brennan Center found, quote, "no statistically significant relationship between bail reform and crime rates," end quote. To summarize, the cash bail system is harming individuals and society. Illinois has demonstrated a viable way to abolish cash bail that reduces incarceration while promoting public safety. The Pretrial Fairness Act should be enacted throughout the United States.
Providing cross-examination for the negative team for 1 to 3 minutes. From Binghamton, Stephanie, a senior majoring in English and likes to read mystery novels.
Okay, first question. What are the problems with the cash bail system? Like, what are the problems with the current cash bail system that you think we should get rid of?
To reaffirm the prior points that I made in the first affirmative contention, the cash bail system punishes the poor by promoting detention based solely on wealth, as well as promoting racism.
Okay. How successful has the policy in Illinois been?
The success can be measured by a decrease in pretrial detention for those that have been released under the PFA.
Okay, so basically like the amount of people in jail goes down if in this policy, like, right?
The amount of people that are detained solely for monetary factors, correct?
Okay. Do you think the similar policy or the same policy would be successful in other states like New York or Connecticut?
If they follow standards similar to the PFA, that I would believe so.
Okay. Do you think that judges, like in a criminal court system, would let out, like underneath your policy that you defined, like, do you think that judges would, rule to let out violent offenders under this no cash bail policy?
Well, I didn't define the policy. The policy was defined by the legislature that passed it in Illinois.
I'm
Mhm.
sorry, that's time.
Okay, thank you.
Um, Presenting the negative team's first constructive argument for 7 to 9 minutes, Ishrad, born in the Bronx, raised in Detroit.
Hey, what up? I'm Rashad. Can y'all hear me? Is the mic on? Okay, cool. Judges, can you hear me? All right, I'll start in 5. Thank you, judges, for your time and dedication today, and thank you for the affirmative for presenting their case on this pressing issue. Debate is about testing competing visions for progress, and today we're going to discuss whether abolishing cash bail nationwide is the right step forward. To frame this round, let me offer you an analogy. Imagine you're cooking soup for a small group of friends. Let's say the recipe works well for 4 to 5 people, but now you have to scale that recipe up to feed hundreds of people. Scaling up the recipe to feed hundreds of people without considering the necessary resources, tools, and different needs of different people could create a disaster when you try to scale up that recipe. And it means some people might end up hungry, you might not accommodate everybody's needs, and some people might be harmed. This is similar to the affirmative's plan to federalize a state pretrial fairness act, which eliminated cash bail solely in the state of Illinois. Their plan is similar to trying to scale up that recipe without considering the consequences. While it might work or seem to work for Illinois, applying it to 49 other states with unique circumstances, needs, and specific risks creates a lot of chaos in the system. In this debate, we'll show why the affirmative's plan is flawed and why the negative offers a better alternative. In this speech, I'm going to present 3 distinct arguments: a spending disadvantage, a federalism disadvantage, and a counterplan. So first, the spending disadvantage. The Pretrial Fairness Act that was implemented in Illinois already faced several challenges in managing the costs associated with ending cash bail. According to the Illinois Policy Institute in 2023, ending cash bail required courts to actually hold more individual pretrial hearings to assess the risk of individual people, which added more strain to judicial resources. Judges, prosecutors, and public defenders were already overwhelmed by the additional workload, and counties were struggling to keep up with the costs. That means if the model got scaled up to the federal level, those problems would only grow exponentially. Without cash bail, many individuals would have to be detained pretrial due to the perceived risk of them being out pretrial, leading to an increased reliance on pretrial detention facilities. The Vera Institute of Justice in 2021 reported that pretrial detention costs local governments an average of $75 per person per day. Their plan would drastically expand the use of detention facilities nationwide, which creates a massive financial burden. Additionally, courts would have to hire more staff to manage the increased number of pretrial hearings, with the Marshall Project in 2022 estimating that Illinois alone would need to spend tens of millions of dollars to sustain the PFA. This financial strain would be way worse at the federal level, where states already struggle with underfunded judicial systems. When public budgets get stretched, the money has to come from somewhere. This creates a trade-off where resources are diverted from essential social services like housing, healthcare, and education. The Urban Institute in 2020 found that reducing funding for housing programs increases homelessness rates by up to 15%, while cuts to public health programs worsen systemic health disparities. The affirmative plan only risks harming vulnerable populations by forcing governments to choose between funding pretrial detention systems and maintaining critical public services. They said cash bail costs $140 billion, so that means that's $140 billion lost that could fund programs like T.R.U.E. Let's compare this to the affirmative impacts. They could claim their plan will reduce racial disparities and incarceration rates, but these outcomes are only speculative. In Illinois, for example, the Chicago Tribune in 2023 reports judges still detain defendants they perceive as risky, which means that there's no actual reduction in who gets incarcerated. Meanwhile, the harms of diverting resources away from housing, healthcare, and education are certain. When social services get underfunded, economic inequality worsens, crime increases, and communities suffer long-term harm. The spending DA outweighs and turns all of their impacts because it guarantees structural harm to millions, while their planned solvency is limited and uncertain. The terminal impact of this is societal collapse. Diverting funds away from essential services only harms the most vulnerable people. It destabilizes communities and it creates long-term cycles of poverty and crime. Their plan only leaves everybody worse off by bankrupting public budgets and exacerbating systemic inequalities. Next, I'll move to the federalism disadvantage. The Pretrial Fairness Act is a state-level policy crafted specifically for Illinois, a state with well-funded judiciary and urban population centers. However, when you scale this model up to the federal level, that ignores the diversity of different needs, resources, and legal systems across the United States. Cash bail is a deeply embedded policy in many states, and local governments rely on it not only as a tool for pretrial release, but for revenue. For example, the Cato Institute in 2022 notes that many rural and conservative states require cash bail systems to fund law enforcement and court operations. Forcing these states to adopt their policy through a federal mandate would undermine their ability to govern. Federal overreach in criminal justice reform provokes significant backlash. We've seen this before. During Prohibition in the 1920s, federal mandates that overrode state preferences sparked widespread resistance and even violent uprisings, as noted by Dan Kellerman in 2020 in his work on federalism and democracy. The affirmative plan risks similar outcomes. Rural and conservative states view the federal abolition of cash bail as violating their sovereignty, potentially leading to increased polarization, noncompliance, and civil unrest. This type of political instability erodes trust in government and weakens the federal system as a whole. The impact is long-term political instability and democratic erosion. According to Kellerman, federalism is a safeguard against authoritarianism by letting states act as laboratories of democracy. Destroying this balance would undermine the legitimacy of the government and create conditions for widespread unrest and violence. Their plan risks tearing apart the fabric of democracy to pursue a reform that's not guaranteed to work. Lastly, I present our counterplan to abolish prisons. Instead of scaling up the Pretrial Fairness Act and its flawed implementation, the negative proposes abolishing prisons entirely and replacing them with transformative justice programs. Angela Davis, in Are Prisons Obsolete in 2003, argued that prisons are the root cause of systemic inequalities in the justice system. Prisons perpetuate racial and economic injustice by criminalizing poverty and marginalizing communities of color. By eliminating prisons, you would eliminate the need for pretrial detention, cash bail, and broader structures that underpin the current system. Transformative justice and rehabilitation focuses on communicative accountability, reparations, and addressing harm at its root. Davis explains that we could redirect resources towards education, healthcare, and restorative justice programs and create a system that heals communities instead of punishing them. Restorative justice is also way less expensive than incarceration. The Justice Policy Institute in 2022 reports that restorative programs cost 80% less per person than incarcerating them, which means the counterplan avoids all of our issues with the spending and costs. The counterplan also avoids the federalism DA because, unlike the affirmative's federal mandate, the counterplan operates through state and local initiatives, which let communities adapt transformative justice programs to their unique needs. This preserves state sovereignty while addressing the systemic inequities that cash bail reforms would ultimately fail to resolve. The counterplan solves better than the affirmative plan. It addresses the root cause of inequality, prisons themselves, which are their argument for why most of the bad things happen under their impacts, which eliminates the need for doing piecemeal reforms like the affirmative while avoiding any of the disadvantage of cost overruns and political backlash. Their plan only tinkers with the edges of the system, but the counterplan creates real transformative change that attacks all of their issues at the heart of the problems. To conclude, let's return to the analogy we started with. They want to scale up a recipe designed for one state and apply it across the entire country without considering all the resources, tools, and diversity necessary to make it work. The result would be disastrous. It would cause financial strain, instability, and harms the communities that they're trying to help. The negative offers a clearly better solution. You would overhaul the system by abolishing prisons, which addresses all the root causes of their impacts while avoiding any unintended consequences of the affirmative's plans. For these reasons, I strongly urge a negative ballot. Thank you.
Providing cross-examination for the affirmative team for 1 to 3 minutes is Ishgar Howard. Ishgar is a founding mentor in the T.R.U.E program, a proud father, grandfather, uncle, and brother who is on a path of atonement for his past choices, a published author, and a Restoring Promise advocate.
How you doing, man? Spending disadvantages, right?
Yeah, you ready?
You ready?
All right, we're good.
So the problem would be it takes longer to hold more, like longer.
Yeah,
hearings.
that's part of our argument. And also that if you eliminated bail, we should not trust judges that they would just let people go without bail before the trial. Our argument is that if you eliminated bail, judges would be like, well, these people are risky, therefore we're just going to lock them up without bail beforehand, which is worse than giving them the opportunity with bail, because at least with bail, you could spend and get out before the trial. Under your plan, they would just lock you up and then say, well, we don't need to have you out before the trial because we don't have bail anymore, which is worse.
That's not what you said.
Yeah,
You-
that is
you-
what we said.
You made the complaint that the hearings would be longer. My question to you is a citizen's freedom not worth taking as much time as possible?
I mean, so the argument above answers that because the whole point is you wouldn't be free before your trial. If it's up to a judge's discretion, they would easily just rule, well, we think the particular person is risky, therefore we're going to put them in trial. So there is no freedom. And the other part of that is spending makes the prison system worse, right? If there's less funds in the prison system, it makes the quality of the prison system worse, which hurts the prisoners more. You're good.
You do realize you're talking to a prisoner, right?
Yeah.
Okay. So the $180 billion amount, you believe that that's going towards prison reform? Like, well, you said for the T.R.U.E program.
I mean, the whole point is not that that money is particularly going, but
Okay.
when they cut the funding, they would have an excuse to cut those programs.
Okay, okay. Another thing was, like, you said it would take resources from
Right.
the police officers.
You're right.
Like, my question is, regardless of what it takes to actually find justice, whatever how much time it needs, you don't think it should be required to do so?
Sorry, what do you
I'm
mean?
asking you, you said it would take resources.
Yeah.
And it would need longer investigations.
Yeah,
From where I'm from, they rush through investigations already as it is.
right.
So why wouldn't they take more time? Why wouldn't we want them to take more time investigating crimes? Why wouldn't we want them to actually work for the money they're receiving?
Well, that's the thing. If they take more time, then it costs more money, that's our argument.
Yeah, but where is the money actually going?
I mean, our argument isn't that the money is perfect now, but taking the money away only makes the system worse. If your argument is it's a flawed system, taking money from them means that it only rebounds on the most marginalized people.
In 2020, there was a COVID pandemic, correct?
Yeah.
People were walking around with masks and
Yeah,
like a lot of people weren't getting arrested, correct?
yeah.
So what do you think would happen if you actually ended prisons?
I mean, I think ending prisons is good because first of all, I don't think police solve or deter crime most of the time. I think that rehabilitation would solve. I think that you could have community sort of patrols that prevent crime in communities. And I think prisons are just ethically, bad. Like
So on
we
one-
should get rid of
So on
prisons.
one hand,
That's time, fellas. Sorry.
Presenting the negative team's first rebuttal for 4 to 6 minutes. Eden, Setting School of Management at Binghamton.
Hello. Thank you, judges, for being here today, and thank you to the affirmative for their thoughtful arguments and an important debate. As the first negative rebuttal, it's my role to demonstrate why the affirmative case fails to achieve its goals. In this speech, I'll respond directly to their plan with 4 arguments that undermine its solvency and expose its flaws. 1, there is no inherency. This law already exists, and their plan proves our federalism disadvantage. You mentioned Preston's work assuming that there is inherency, but your plan is modeled on the Pretrial Fairness Act, a law that is already in effect in Illinois. This means that there's no inherency because the affirmative is defending a law that exists in the status quo. If the plan is merely an endorsement of the Illinois model, then their solvency is extremely limited. They cannot claim to solve nationwide problems because their advocacy is restricted to a single state. If the affirmative plans to mandate the Pretrial Fairness Act nationwide, this directly triggers our federalism disadvantage. Extending from the previous negative constructive, a federal mandate to abolish cash bail would undermine state sovereignty by forcing states with vastly different legal systems, demographics, and resources to comply with a one-size-fits-all solution. For example, states like Texas and Alabama have very different pretrial systems compared to Illinois. And the Cato Institute in 2022 highlighted that rural states often depend on cash bail revenue to fund law enforcement and local courts. A federal mandate would disrupt these systems, creating backlash from conservative states that see this as a federal overreach. This backlash risks political instability. David Kellerman, in 2020, explains that federalism acts as a safeguard against authoritarianism by allowing states to maintain autonomy over local policies and create conditions that avoid civil unrest. The affirmative plan proves our federalism disadvantage because it shows how a state-level reform, like the Pretrial Fairness Act, is more effective when implemented locally. Their attempt to scale this reform federally risks tearing apart the political fabric of the nation. 2, the affirmative plan whitewashes the prison system and masks systemic injustice. The affirmative claims their plan solves systemic inequalities, but this reform merely creates the illusion of justice, while leaving the root causes of inequality untouched. Abolishing cash bail does not address the larger issues of mass incarceration, over-policing, or racialized criminalization. Angela Davis, in Prisons Are Obsolete, explains that reforms like these often pacify public outrage by giving the appearance of justice, making it harder to mobilize against the systemic inequities perpetuated in the prison system. She writes, "The call for prison reform tends to produce situations that legitimate the very institution it seeks to transform. Here's how this works under the affirmative plan. By ending cash bail, the justice system appears fairer to the public, even though the same racial and economic biases remain in play. Judges under the Pretrial Fairness Act still have broad discretion to detain defendants if they're perceived as high risk, which disproportionately affects Black and Brown individuals. The Chicago Tribune in 2023 reports that racial disparities in pretrial detention have persisted in Illinois even after the implementation of the PFA, with minority defendants still far more likely to be detained than their white counterparts. This ties directly to the negative counterplan. Abolishing prisons addresses the root causes of systematic injustice instead of perpetuating them through surface-level reform. Angela Davis argues that prisons themselves are the primary source of racial and economic inequality in the justice system, and the negative counterplan eliminates this harm entirely. The affirmative plan, by contrast, simply whitewashes the system, making it harder to identify and fight against these injustices in the future. 3, more people end up indefinitely held without the possibility of cash bail. The affirmative mentions a statement in the Vermont Law Review, but their plan will not reduce pretrial detention rates. Under the Pretrial Fairness Act, judges have significant discretion to detain defendants they deem high risk. The Brennan Center for Justice in 2021 explained that this discretion often leads to racialized decision-making, with Black and Brown defendants disproportionately labeled as dangerous and detained. Even under the Illinois model, minority communities are still more likely to face indefinite pretrial detention. The affirmative plan also tilts the pretrial process in favor of the state. Defendants only have 48 hours after arrest to prepare for a pretrial hearing, during which they must prove they are not a flight risk or a danger to the community. The National Association for Public Defense argues that this timeframe overwhelmingly benefits prosecutors, who have greater resources to build a case, while overwhelming public defenders lack the time or tools to adequately represent their clients. Wealthier defendants, on the other hand, can hire private attorneys, are better equipped to argue for their release. The affirmative plan doesn't solve these harms, it just shifts them when and how they occur. While cash bail is an imperfect system, eliminating it entirely leaves marginalized communities more vulnerable to indefinite detention. Finally, the affirmative plan still creates economic bias. Even without cash bail, wealthy defendants still have massive advantages in navigating the justice system. They can hire top-tier lawyers, private investigators, and experts to mount a stronger defense. Meanwhile, low-income defendants rely on underfunded public defenders who lack the time and resources to provide robust representation. The Marshall Project found in jurisdictions with cashless bail systems.
That's time. I'm sorry.
Thank you.
All right. Presenting the affirmative team's first rebuttal for 4 to 6 minutes, Declan Cott. Declan's a junior mentor in the T.R.U.E program, loves to serve his community, whether it was volunteering at his town's volunteer fire company or spending time with his mentees here in the program. He spends much of his time studying finance, economics, with the goal of one day becoming a self-employed options trader with aspirations in politics.
Ready to go? Good evening, everyone. I'm here to present the affirmatives first rebuttal. First, I'd like to address the fact that the negative addressed there being an increased financial burden on the state that the Pretrial Fairness Act or a derivative of would be implemented. First of all, this is empirically denied. Illinois has abolished cash bail for over a year now without any adverse financial effect. Second of all, eliminating cash bail saves money. The American Center for Progress says that cash bail costs $140 billion per year. We cited that evidence in our first affirmative speech. These costs include incarceration, the use of homeless shelters, public assistance, and public defenders. Third, the funding the court system by imposing bail fees on the poor is simply immoral. Taxpayers should support the court system. I'd also like to add that according to Ali Preston from the Center for American Progress, Broward County, Florida, a different example, spends just $7 per day to release a defendant to a pretrial services agency versus $115 per day to incarcerate them, more than 11 times the amount. Also, one of the things that the negative claims is that more people would be detained pretrial. First of all, in our first affirmative, we state otherwise, but additionally, Bryce Covert, a writer for The Nation referring to Illinois, reported on December 2nd, 2024 that, quote, researchers at Loyola University studied 89 counties in the state and found that of the 25,000 people whose charges made them eligible for detention, only about a third were sent to jail, end quote. He also reported a 14% decline in jail populations in urban counties and 25% in rural counties. Additionally, a third example of how the cost would be less. Harris County, Texas, Brandon Garrett, a Duke law professor, stated in 2024, quote, in examining the comprehensive impact of these changes on Harris County Criminal Justice Department's arrestees and victims of crime, we estimate that the overall costs have been reduced by $2,688 per case, end quote. Clearly, this quote shows that in Harris County, the financial costs of the courts do not increase due to the elimination of cash bail, as the negative has claimed. Next, the negative claims that this financial shortfall would cause a societal collapse, in essence. This is false. What I believe is that the cash bail system would actually create a societal collapse in the end. Shown by Ali Preston and Rachel Eisenberg from the Center for American Progress, they stated in 2022 that, quote, paying commercial bail premiums often leads families to incur debt or sacrifice paying for necessities. If somebody cannot pay the full premium, many states allow for premiums to be financed. The excessive fees associated with these premiums trap people in cycles of debt, end quote, sometimes indefinitely. That is unsustainable. It cannot continue. This in itself would cause societal collapse. They also spoke about a woman named Demaria Tarver, who in 2008 was arrested on possession charges in Baltimore and was unable to pay the total amount of $27,500. Tarver's mother put down a $5,000 down payment and entered into a payment plan with a commercial bail agent for the remaining $22,500. The charges were dropped, but Tarver's mother was still responsible for paying the remainder of the premium, which included a $300 a month payment that they were unable to pay. Ultimately, the debt collector added interest on this debt, and they were unable to pay it, effectively leaving them in indefinite debt. Next, I'd like to address the fact that the negative claimed a federalism disadvantage and claimed that we cannot scale the system up. First of all, we're citing it as an example, a starting point, not the be-all, end-all. Second of all, they claim that derivatives of the Pretrial Fairness Act would weaken trust in government and cause a failing public opinion. What I believe instead would cause a failing public opinion is that when the public finds out that cash bail actually increases crime. This can be shown by the fact that the cash bail actually increases crime through impoverishing individuals. And the fact that poverty causes crime, according to Eric Dolan, editor of SciPost, in 2024, that a, quote, study encompassing data from 1990 to 2020 reveals that states with the highest levels of poverty and income disparity experience the most significant spikes in homicide rates, end quote. Additionally, in a study involving data from 166 countries, Jan van Dijk of the Netherlands Study Center for Crime and Law Enforcement said in 2020 that the finding of the study is that the motivational factors of poverty are the more important predictors of common crime. So clearly there's a connection between poverty and crime. So if you're forcing people who are impoverished to pay bail fines in the first place and simply impoverishing them even more, therefore cash bail causes increased crime by itself. Next, I would like to address the negatives last counter, which is their counter plan to abolish prison. So I thought this was kind of ironic in a sense. It's like sending a student from first grade to Harvard. You can't release people after sometimes decades in prison with no guidance, no help, abandoning people, and effectively throwing them to the wolves, right? So first of all, the Pretrial Fairness Act actually works towards this counter plan through the complete elimination of money bonds in Illinois. Kit Nist, the JD candidate at Wake Forest Law School, said in 2024, quote, "The act weakens the power of the carceral state to jail and punish by fully eliminating money bail," end quote. One of the key tenets of the abolition of jails. Nist also goes on to explain that the Pretrial Fairness Act challenges all aspects of the prison industrial complex, thus shrinking the power of the industries and elected officials that profit off it. The negative brings this counterplan, but neglects to include that eliminating cash bails, we argue, actually begins to accomplish their counterplan in the first place. Quote, "The act was written," also by a Kit Nist, I'm sorry. Quote, "The act was written by abolitionists, for abolitionists, fought for by abolitionists, and is a groundbreaking advancement of abolitionist reforms into state-level policymaking," end quote. Thank you very much.
We've now reached the halfway point of the debate, leading us in the opening second round by presenting the negative team's second constructive argument for 6 to 8 minutes. Eli, a senior, an English major, and a substitute teacher. Is everyone ready? Okay. Thank you, judges, and thank you to my opponents for your insightful responses. In my speech, I will start by extending our main arguments, and then move on to some of their more specific arguments. So first, I would like to extend our federalism disadvantage and our inherency argument from Case. As my partner explained in the first negative rebuttal, the affirmative's case lacks inherency because they are defending the Pretrial Fairness Act, which already exists in Illinois. If their plan is just the PFA, it means they aren't actually solving anything new. But if they try to mandate the PFA nationwide, this triggers our federalism disadvantage. They say that their plan is not just the Illinois PFA. However, that is the only example that they used in their opening speech, and the only things that they mentioned about what they were going to do with the incarceration system was things directly taken from Illinois. So I urge you to consider that. And federalism isn't just a technicality, it's the foundation of American governance. The Cato Institute in 2022 warns that federal mandates overriding state policies create mass political polarization, especially in conservative states that strongly oppose federal intervention. This isn't hypothetical. History shows that sweeping federal criminal justice reforms often provoke state resistance. As my partner cited from Daniel Kellerman 2020, federalism protects against authoritarianism and prevents national overreach. When states lose autonomy, citizens lose faith in government, leading to increased civil unrest and potential violence. The affirmative's plan forces a one-size-fits-all model onto states with vastly different needs, triggering these exact harms. And if it doesn't, as they claim to not use the Illinois plan, they are going to spend a needless amount of money making sure that this individually fits every state, which is also impossible. Next, I would like to extend our counter plan and our whitewashing argument from Case. The affirmative's plan makes the justice system seem fairer without actually fixing its fundamental problems. Angela Davis, in Our Prisons Obsolete from 2003, warns that surface level reforms like eliminating cash bail trick people into thinking real progress has been made, making it harder to mobilize for radical actual change. The Abolish Prisons counterplan is the only way to remove the root cause of these injustices. If there are no prisons, there's no need for cash bail, pretrial detention, or judicial discretion that disproportionately harms marginalized communities. And they have not responded to this. We stated that the injustices such as like racism and classism within the incarceration system are due to the system itself, which was never answered. So these marginalized communities will only continue to be harmed. As my partner explained, restorative justice programs cost 80% less than incarceration. Justice Policy Institute 2022, meaning our counterplan avoids the spending DA while actually solving the problem instead of masking it. They claim that some states, such as Texas and Florida, I believe it was, have counties and cities that cost less to have their pretrial than it is to incarcerate. But again, Illinois does cost significantly more to incarcerate or to do their pretrial than it does to incarcerate them. And every single state, every single county, and every single prison is completely different. So there is no way to know how this will affect the economy and the system other than to have it happen, and it could be very disastrous. Now, I would like to extend our argument on case concerning how the elimination of cash bail might lead to indefinite detention. As my partner argued, the affirmatives plan still leads to indefinite detention for many defendants. The PFA allows judges to detain individuals accused of violent or high-risk crimes, and judicial discretion is often racially biased. The Chicago Tribune from 2023 found that even under the PFA, Black and brown defendants are disproportionately labeled as high risk and detained at higher rates. This means no real progress would happen, and it would only hide it. Additionally, the 48-hour pretrial hearing limit makes it harder for defendants to contest detention. The state has near limitless resources, while low-income defendants with public defenders struggle to mount a defense in time. The Marshall Project from 2021 found that in states with rapid pretrial hearings, pretrial detention rates actually increase because defense teams don't have adequate preparation time. This means the affirmatives plan entrenches racial disparities instead of solving them. And then I'm going to extend a couple of things that my partner mentioned in the last speech and continue on to a little line by line. The affirmative argues that cash bail is disproportionately harming marginalized communities. However, eliminating cash bail does not eliminate racial disparities. It just shifts discrimination to a different stage in the process. So the Chicago Tribune mentioned before reports that even under the Illinois PFA, Black and brown defendants still detained at higher rates. Because judges have more discretion to determine who is a threat based on their own opinion. This means that eliminating cash bail does not stop the racial bias, just makes it harder to see. Additionally, the wealthy still have advantages under the affirmatives plan. Defendants with private lawyers are significantly more likely to secure pretrial release, even in cashless systems, because they have the resources to argue against detention. This proves that the affirmative does not eliminate discrimination, it just moves that discrimination to the pretrial hearing stage. And then the affirmative might claim that cash bail is expensive because detaining people costs more than releasing them, again mentioned before. However, this ignores the massive cost of pretrial hearings and increased judicial workloads under the PFA. The Illinois Policy Institute from 2023 found that counties in Illinois are already struggling to cover the cost of holding more pretrial hearings, which we mentioned before. Ending cash bail means courts must evaluate every defendant individually, requiring more judges, more clerks, and more public defenders. These administrative costs add up. Additionally, as the Vera Institute of Justice from 2021 reports, pretrial detention still costs $75 per person per day, and with cash bail eliminated, the more people end up detained indefinitely due to judicial discretion. The affirmatives plan does not eliminate costs, it just redistributes them to pretrial detention and legal bureaucracy. This turns their solvency against them and reinforces our spending DA. And just as one more thing I want to mention, the opponents mentioned that we were going to throw out incarcerated individuals onto the streets if we ever abolished the system. That is not at all what this plan is for. This plan is to create more spaces like this one, like this program, that are able to actually help individuals who need help instead of locking them away to facilitate more money for the US economy. Did we ever say that we would throw individuals off the streets? We did not. We said that we can use the money that's flowing through, the hundreds of billions of dollars that's flowing through the incarceration system and needlessly, and then we can spend that on the prisoners that actually need the help. I'll stop there. Thank you. Presenting the affirmative team's second constructive argument for 6 to 8 minutes, Christopher Sakowitz. Christopher. Christopher, who also goes by Big Al, is a true program legend, often referred as the true mascot, who has a knack of making friends with every person who walks through the door. He has a flair for the dramatic and is an avid Dungeons and Dragons player.
Hello. Greetings, judges and esteemed opponents. My name is Christopher Sakowitz, and I'm here to affirm our prior contentions as well as advancing 3 new arguments against cash bail, including that it harms families and children, it facilitates the exploitation by the bail bonds industry, and it reaffirms racism. First, I will talk about how the cash bail harms families in our communities. Imagine you're a single mom who's currently working 2 jobs to support your 3 kids in a Section 8 apartment, and you're only making ends meet. All of a sudden, you wind up in a holding cell in the local precinct for shoplifting. Now you have a decision to make. You could pay your bond or go home to your kids and remain in, or you could pay your bond and go home to your kids or remain in jail and await trial. This fear is a reality lived out by millions of Americans on a daily basis. According to a 2024 article by Allie Preston, a senior policy analyst at the Center for American Progress, quote, many people are held in jail on bail amounts as low as $250 or $500. People often must rely on family members and friends to supply bail money, thus spreading the economic impacts across families and communities. It's not uncommon for people to have to forego paying for electricity, food, or rent to afford bail, end quote. The cash bail system is driving people into a life of poverty. Sean Freeland, JD of Lincoln Memorial University, stated in 2023, quote, money bail contributes to poverty and recidivism. Every day that a defendant is kept behind bars, their ties to the communities are weakened. Their relationships with family and friends are strained, while employment and educational opportunities are lost. Even a day in jail may cost many workers their jobs. Defendants who cannot afford pretrial release are convicted at higher rates, sentenced to prison more often, and receive longer sentences than defendants who are awarded pretrial release, end quote. All of these are things to contribute to impoverishing individuals and their families. By increasing family poverty, the cash bail system leads to more crime. Numerous studies prove that poverty causes crime. A 2022 study published in Evolutionary Human Sciences examining data in the United States from 1990 to 2020 found that states with the highest poverty rates experienced higher homicide rates. Another study published in the Journal of Quantitative Criminology in 2022 looked at data from 166 countries and determined a strong link between poverty and the incidence of common crimes like burglary. Another harmful consequence of cash bail is that it causes family separation. According to a national survey of jail populations, 53% of men and 66% of women who are incarcerated for an inability to pay were parents of minor children. This means that pretrial incarceration frequently separates children from their parents for extended periods of time. Separating children from their parents is harmful to their upbringing. Allie Preston of the Center for American Progress stated in 2022, quote, children who have incarcerated parents tend to experience higher rates of depression, anxiety, post-traumatic stress disorder, and suicidal ideation than children who do not have an incarcerated parent, end quote. A second negative outcome of the cash bail system is the operation of the bail bonds industry. If someone is charged with a crime, they are unable to post bail. They have the option to go to bail bond company for assistance. A bail bonds company is a for-profit business that charges a non-refundable fee in exchange for posting bail. The bail bonds company posts the bail for the defendant and agrees to be liable for the full bail amount if the defendant fails to appear in court or otherwise forfeits his or her bail. While this may seem like a good deal for the person to get out of jail, very bad outcomes are the norm. Bail bonds companies earn in excess of $2 billion per year by exploiting and taking advantage of the poor. One way they do this is by charging a non-refundable fee as much as 10 to 20% for receiving a bond. These non-refundable fees create a big economic hardship. Nicole Manzano of the Bail Project explained in 2023 that extracting money via a non-refundable fee causes, quote, low-income communities permanently to lose access to critical economic resources, even when the charges are dropped and there's no evidence of wrongdoing is found, end quote. A second way the bail bond industry exploits people is by charging outrageous financial fees. If someone cannot pay the full premium amount at the time of signing a bail agreement, many states allow for premiums to be financed. Paying these premiums traps many people in a perpetual cycle of debt and poverty. Allie Preston and Rachel Eisenberg for the Center for American Progress argued in 2022 that, quote, fees associated with bail bonds are so expensive that some people end up paying more in fees than their total bail assignment, end quote. One example that they cited is from a father that was charged a $19,500 recovery fee after his daughter missed her court date. That fee extended the original bail amount, which was for $15,000. A third adverse consequence of the bail bonds industry is their use of bounty hunters to locate persons who fail to appear for the court date. Bounty hunters have broad powers to detain and arrest individuals. This is because the contracts clients sign to waive their right to privacy and consent to permit any use of force to guarantee their return. Therefore, bounty hunters are not required to have a warrant to apprehend somebody. These broad powers are frequently abused by bounty hunters. Allie Preston and Rachel Eisenberg for the Center for American Progress noted in 2022, quote, many bounty hunters take advantage of this consent and rely on violence to collect payment and return individuals to custody. These practices harm not only individuals accused of the crime and their co-signers, but also innocent individuals mistakenly identified by bounty hunters, end quote. Our third harm to the cash bail system is that it exacerbates racism and classism. There is an overwhelming evidence that Black and Latino individuals experience discrimination in pretrial detention decisions. Natasha Brown, a JD candidate at the UIC Law School, wrote that in 2024, quote, the United States Commission on Civil Rights reported that Black and Latino individuals have higher rates of pretrial detention than any other demographic, not based on their potential harm to a community, but inability to pay, end quote. Nicole Manzano, senior policy counsel at the Bail Project, observed in 2023 that, quote, when comparing Black and white individuals in one study, Black defendants were 3.6% more likely to be assigned bail, end quote, rather than being released on their own personal recognizance. Racial discriminations also exist in determining bail amounts. Allie Preston of the Center for American Progress noted in 2022 that, quote, bail amounts for Black and Latino men are 35% and 19% higher, respectively, than their amounts for their white counterparts. Most people who are unable to afford cash bail are from the poorest 1/3 of society, end quote. Nicole Manzano of the Bail Project states that Black defendants, quote, receive bail amounts that are on average $7,280 higher, end quote. Cash bail creates a two-tier system of justice, whether you're either able to pay and able to fight for your innocence to the best of your ability with every resource at your fingertips, or sit locked up, only able to access legal materials for an hour twice a week. This unfairness of the cash bail system calls into question the integrity of our criminal justice system. We conclude with the quote from Nicole Manzano, senior policy counsel of the Bail Project, when she says, quote, cash bail's resulting economic and racial inequalities undermines the entire criminal legal system, end quote. Thank you very much.
All right, presenting the affirmative team's second rebuttal for 3 to 5 minutes, Alex Cruz. Alex, who goes by Lex, recently completed both his associate's degree in vocational education and cosmetology. He aims to complete his MSW to become a therapist working with at-risk youth and foster children, along with becoming a celebrity barber.
Thank you, judges, for this opportunity. Thank you for the negative team, this opportunity as well. I'm gonna start. As we move forward in this debate, it is crucial we address points made by the negative team. The negative team presented arguments that it claims that the sweeping federal reforms will incite civil unrest and fuel violence. This is simply an assumption, nothing more. The negative doesn't take into account that the public opinion can change, and will take into account that once they see that the financial savings increased safeties in our communities due to falling crime rates and families reunited with their loved ones. The negative also claims Black and brown defendants still detained at higher rates, but cites no empirical evidence, purely anecdotal, the weakest type of evidence. The negative also claims that our reforms are not enough, does not fix harms of the justice system, but we are not trying to overhaul the entire system, only to improve pretrial detention system by abolishing cash bail. So this claim is also irrelevant. The negative team also argues for abolishing prisons while also looking to fund and build prisons like ours. This claim is contradictory. While we aim to ban all detention for misdemeanors and low-level offenses, let us remind ourselves, but it's substantive arguments laid by our second speaker, which the cash bail industry harms families and communities, causing them to forego necessities such as food, rent, electricity for their liberty. Operations of the bail bond industry allows for bounty hunters to broad powers to detain and arrest individuals. The cash bail also creates a two-tiered injustice system, perpetuating classism and racism. In light of the arguments and the evidence that the affirmative team are presenting, the elimination of cash bail and detention for misdemeanors to low level of felonies, as proposed in the Pretrial Fairness Act, we are advocating a policy that is feasible, deliberate, and practical. Our plan seeks to prevent and create the creation of a cascading of consequences
Those are the traumas of incarceration on citizens still presumed innocent, the ramifications of civic, economic, and social disruptions that incarceration inflicts. And it seems like the negative is letting the perfect be the good of the enemy of the good. Our system is not meant to be perfect, but meant to reduce the most harms while still promoting public safety and the liberty of one person shouldn't infringe upon the liberties of another's. While the idea of abolishing institution, it has been an idea that's been circulate in society as such, it has yet to materialize and produce a measurable outcome for individuals negatively impacted by these harmful systems. And meanwhile, the PFA has transcended being an idea and materializing as legislation and providing statistics that do prove the benefits of benefiting actual lives while we debate over its merits. Thank you for our argument's consideration and attention.
Presenting the negative team's second rebuttal for 3 to 5 minutes, Lucas, a junior political science major.
Okay. Thank you, judges, for your attention throughout this round, and thank you for everyone for their contributions to the debate. At this point, it is clear that negatives abolish prisons counterplan is the most effective and transformative solution to systemic injustice. This is identified both sides. Also, we're dropping the federalism and spending DA, just using it to test the affirmative. Yada yada yada. The affirmative's plan tinkers with the system by eliminating cash bail, but it leaves the core structure of incarceration intact, ensuring that the same patterns of racial economic oppression will persist. Angel Davis, in Our Prisons Obsolete in 2003, argues that prisons are the foundation of systemic inequalities in the justice system, perpetuating cycles of violence, poverty, and racial oppression. Reforms like the affirmative's plan, Davis explains, only provide the illusion of progress, whitewashing the system, pacifying public outrage while leaving the root causes of the harm untouched. Counter plan, on the other hand, limits prisons entirely, addressing these root causes by replacing them with restorative justice programs that focus on accountability, healing, and reinvestment in communities. Without prisons, there is no need for cash bail, pretrial detention, or judicial discretion that disproportionately harms Black, brown, and low-income communities. The affirmative's plan cannot claim these same benefits because it maintains the very structures that produce injustice. The counter plan also resolves the spending disadvantage, with the affirmative has failed to engage with adequately restorative justice programs, cost significantly less than maintaining the current carceral system of the Justice Policy Institute 2022, finding that these systems programs cost current carceral system with the Justice Policy or I read that 80% less person than incarceration. This allows us to reinvest billions of dollars into vital public services like housing, education, healthcare, which addresses systemic inequities driving crime. In the first slice, in contrast, the affirmative's plan increases costs by expanding pretrial hearings and detention systems, as evidenced by Illinois Pretrial Fairness Act. According to the Illinois Policy Institute 2023, counties in Illinois are already struggling to cover the administrative expenses created by eliminating cash bail, including need for more judges, clerks, and public defenders. The affirmative plan creates a resource trade-off that harms the very communities they aim to help, while the counterplan solves more effectively and avoids these economic harms. Ultimately, the counterplan wins this debate for 3 reasons. First, it solves the affirmative's harms better by addressing the root cause, prisons themselves, and creating a system that is equitable, accountable, and focused on healing. Second, it avoids the economic trade-offs identified in the spending disadvantage, and reinvesting resources in programs that strengthen communities rather than drain them. Then it avoids the false progress of the affirmative plan, which risks reinforcing structural injustice by making people believe the system is now fair when it clearly is not. For these reasons, the counter plan is the most effective and transformative option. I strongly urge negative ballot. Also, as far as case goes, they didn't address the fact that rich people can just pay more for pretrial hearings, and that just as much has an effect on bail itself. Yeah, and also on the counter plan, they say we never said we want to build more prisons. We want to transform prisons from their current state, and that we don't have any evidence to cite for transformative justice system. That's not true. We just look at Europe. They have a transformative justice system where there's a very high and much lower recidivism rate, and much lower recidivism rate, as the affirmative has said, is linked directly to poverty, and lower, given that there is a less recidivism rate, I can't say that word, in Europe, that means there's less poverty for the communities that have higher there's less poverty in the communities that are more impoverished. And therefore, it means there's less from that cyclical system, there's less poverty and crime overall, and therefore that system is perfectly capable, has been observed throughout the world. It's just the United States that has such a broken justice system. Just because we live in the United States doesn't mean we have to keep up the flawed system of justice that the United States holds. Yeah. And again, the affirmative also mentions incarcerated parents from cash bail causing the children of those parents more mental instability. The counterplan also solves because, again, transformative justice includes socializing the prisoners with their parents while they're incarcerated. That's a very important part of informative justice. There's many benefits that informative justice has that, or reformative justice has, that the affirmative does not solve for. The affirmative overall is just a rubber stamp solution to a much wider problem that we do have an example of a way in which we could solve, which is through rehabilitating people who are struggling rather than just locking them up and making the process for locking them up more simple when we could solve for the problem of locking them up in the first place. And yeah, I urge you to vote neg because the counterplan is the most effective option. Thank you.
Now both teams will present closing remarks for 90 seconds, beginning with the affirmative team from the T.R.U.E. Ishkar Howard.
I would first like to thank the judges and students for participating in this debate. I would then like to begin my closing with, within the First and Fifth Amendments of the Constitution, the word accused does not exist when it comes to stripping civil liberties. This debate is not solely about if cash bail is unconstitutional or an economic burden on taxpaying citizens. This debate is about the judicial system relinquishing power and control through racism and classism. We've counted every statistic and quote cherry-picked by the negative team and clear overwhelming evidence that supporting eliminating cash bail and incorporating the PFA. Do we hope one day it will lead to abolishing prisons altogether? Sure. We just understand that the system didn't evolve into a corrupt one overnight. Once learning that 70% of the people incarcerated in this country are unsentenced, you would think we win just by that. If a citizen is on their way home from work and gets stopped by the police and is identified as a suspect of a robbery, is it really okay to demand them to spend money just to not go to jail that night, even before defending themselves against the allegations? We are talking about children left without care and support, loss of employment, defamation of character, institutional, mental, and physical abuse, along with the risk of losing your life savings. Cash bail is a multi-billion-dollar business that has absolutely nothing to do with justice and therefore should be eliminated. Thank you.
We will now hear the negative team's closing remarks from Binghamton, Stephanie.
First off, I would like to say great debate, everyone, and thank you, judges, and thank you all for having us and everything. But pretty much the counter plan solves because they even said it themselves that the PFA and getting rid of it is the first step towards ending the prison system eventually. But we should take action now and end it completely because the things that they indict, which is racial discrimination and wealth differences and parents without child, they're all stigmatizations of the prison system itself, not just cash bail. Eliminating just part of the problem does not eliminate the effects of the whole. And yeah, so this one, like the counterplan solves without counterplan solves because we would be getting rid of the stigmatization of being incarcerated because there would we wouldn't be doing things such as incarceration because we would be focusing on reformative measures rather than having prisons. Like we never said we wanted to increase prisons. We want to actually just make institutions that are reformative and not a prison. So yeah, instead of just waiting for the system to eventually realize that it's problematic, we should take action now because the system will always repeat the same cycles of violence and same problematic issues that we have unless true action is taken advantage of, and just because it hasn't worked yet doesn't mean it couldn't. Like, that means you vote on presumption because yeah, if we successfully prove that the prison system itself is bad, then that means you should get rid of the entirety of it, then rather than focus on a small part like cash bail, which is problematic, but we would basically solve for all the basically solve for all their issues and avoid things such as suspending DSAT or like forcing states without less resources or different circumstances to comply. Thank you.
All right. As the judges tally scores, and I believe they will send it over to our chief judge. Rita, if there are any split decisions, the decision will be handed to the team with the highest score. In the meantime, while the judges are calculating their scores, I also want to recognize two other individuals that are on the T.R.U.E team that didn't have speaking roles. One here in person, Damian Thomas, often referred to as Roz, a respected mentor in the T.R.U.E unit. Mr. Thomas strongly believes in and is vested in prison rehabilitation. Mr. Thomas hopes and continues to promote that the work being done in the T.R.U.E unit is seen as the norm and not the exception. So we want to thank, Damian Roz for his contribution. And then the second team member, we are ecstatic to see is joining us virtually. Gilfredo Santiago is joining us online, was also participated in the debate team last semester, worked on this team halfway through and thankfully is now home. And so I don't actually know if he's able to speak, but he's there and we just want to recognize you for your support for the team. I think that's everyone. Again, I just want to extend the thanks that Daniel mentioned in the beginning of this debate for DOC and the T.R.U.E unit, all of the counselors that work to make this happen every single week. The amount of legwork that goes in the back and forth that they assist in making this all happen, in the research that you all had sifted through, and the support that you all gave us. Thanks. And then for you all driving down here and engaging in this debate is, really amazing. So we thank you again for that. All right, I don't want to be up here any longer, so I'm going to offer this mic to anyone who wants it to just sort of talk about if you have any additional words on your experience or thoughts about the debate. And
Yo, definitely thank you for this opportunity. I appreciate the professors who've helped both sides, both teams. This program is amazing because of just the camaraderie we built over time, learning about policy, the process it takes, and also debating. It was amazing. I appreciate y'all arguments. It was hard for me to make this argument. I'm going to confess, because I'm an abolitionist at heart. So y'all helped me with that one, and I was just like, oh man, I knew it was coming. But I appreciate it though. I do. I appreciate y'all arguments, but that's the thing about debate. I think debate, right? One thing that they realized was that no matter what stance you took, there was always a counter argument. There was a vulnerability in any stance that we took, and that was a long process. We debated amongst ourselves, so that was just a long process. And even that is helpful, because I think debate at the end of the day is it's about gaining more truth, right? Getting to more both sides of these arguments, presented two different sides to the issue, and what do we walk away with? What do we learn about this issue? So I think you guys presented some good stuff that I was enlightened by too. So I appreciate it. And all the Angela Davis. Hello, everybody. Yo, Y'all, y'all are so brave for coming up here. I live here and I was about to fall out doing this, honest to God. Like, congratulations. It takes a lot of guts to stand up in front of a room of people, you know what I mean, and speak like this. So, for real.
Yeah, that's out. That's out.
Hey, my name's Declan Cott, and I just want to come up here and share some of the same sentiments. I really appreciate all y'all coming in here because, you know, I just before I came to prison, I was in college as well, and when I was at that point in my life, I could never have imagined walking in one of these places willingly, right? And it shows a lot in your character to be willing to do that in itself. But I also appreciate your time and everybody else as well. You know, everybody for organizing it because I know time is a very valuable resource. And I appreciate all of you for that. Anyways, and also I want to say that, you know, not to say anything, but we got a pretty good argument. You know, I even changed my own mind. I came into this process pretty skeptical actually, and after looking at all the data from both sides, I kind of changed my own mind. So, yeah, thank you.
Does anyone from Binghamton want to, there we go, Coach Schatz.
Yeah, I'll jump up. My name is Joe Schatz. I'm the Director of Debate at Binghamton University. This is my second year with the National Public Debate Prison Debate League. Each time it gets better and better. Last year I got to judge the wonderful team from T.R.U.E and I got to vote for them. Hopefully it's a different decision this year. But you know what? They did an incredible job. Like a lot of times debates are just people talking in parallel with one another, but they did an amazing job like answering the arguments going into it. And when we came here to prepare, I was like, how could we come into a prison and be like, let's keep cash bail? And so we thought about like, how can we come up with a prison system, or how can we help create a reform system where we could address the people, whether you're inside or outside, because you're all people. And like being able to have these form of engagements allow us to be able to have a real form of communication where we could really see the humanity in each other and sort of figure out ways for us to move forward together. And I really appreciate you letting us to come into this space for us to be able to have this debate. And also, like, people haven't given the shout out yet to Daniel or Brittany or John for being able to put the National Prison Debate League together to be able to have this. And so thank you so much, you know, for putting this together, and thank you all for having us here. Thanks a lot.
No, Brittany, you were right too. You knew to argue it too.
Barely. I just started. Thank you. Yeah, no, I usually script these kinds of things for myself. Was not aware this was a thing. Hello. I just wanted to say I think this is an amazing program. I think that restorative justice is so important, and like seeing you guys actively just coming and having conversations with us and talking things through, I feel like it really has done some work in like a really positive way, and I really hope that all of this continues and the work we do in debate translates to the work in the real world and not in a messed up way. And I hope yeah, I hope that I get to see you all again. And yeah, it was very amazing. Thank you.
Thank you. Yeah, let's go.
Can y'all hear me? Can y'all hear me? Okay. I just wanted to share a bit of my own experience. I debate with a Black woman who's from Brooklyn, and our topic is about climate change. And a lot of the stuff we talk about, you know, against other colleges like Harvard and Dartmouth is about centering anti-Blackness and the ways that people get pushed out of the side and left out of the conversation. And, you know, it was interesting. We kind of had a moment in Crosslex where he was like, you know, do you know you're talking to a prisoner? We have a lot of those exchanges in the debates me and my partner have, where people talk crazy and disrespectful. And we try to recenter that lived experience and talk about the conditions Black people have to actually come from to make it to the debate space to begin with. And a lot of times people haven't assumed that in debate, you know, because there's been a lot of white upper class people from elite institutions. And so I just want y'all to know that, like, we are really trying to do the work of like trying to center people's lived experiences who are not included within the system, you know, and make sure that, like, for all the people who don't get to, you know, come into the debate space, who don't have access to the academies and universities, we want to represent them and make sure that their experience is being centered and that it's not just left to rich white people who have the ability to afford college, like we want to center people who get pushed out and talk about those people because they're the ones who get left behind when it's only rich white people talking. So yeah, I just want to say I really appreciate engaging y'all and having that conversation. It's definitely leveled up our game, just getting to interact with y'all. And yeah, it was really fun.
Thank you. Okay, John, let's go. Yeah. John, Big John. John, that's Big John, y'all. What is that? Yeah, that's Big John, y'all. Big John.
I've been in a lot of prisons as part of the NPDL. I debated in a prison when I was an undergraduate. I was at the Norfolk prison. I took BC to the Norfolk prison. I've been to the Maine prison. I've been to the Ohio prison. In the Ohio prison, we debated in a gymnasium. In the MCI prison in Maine, we debated in a recreational room. I must compliment, this is the best venue for a debate. There's nothing better than debating in a kind of a cell block. This is the first time I've ever kind of experienced it, and it's so enjoyable. I got to bring the BC team has to debate in the cell block, and I might leave a few of them in the cell block.
John Katsoulis, everybody. That's a tough act to follow, John.
We got one more.
Absolutely.
Hi, is Bill still on? Hi, anyone? Is William still on?
Rita, I'll connect with you in the chat, Rita.
Okay, because I only have one other judge's ballot.
Yeah, I'll connect with you in the chat.
Okay.
Clown, I'm about to say Bill is down here. First and foremost, thank you for this experience again. Is great, but I really want to talk to my young guys, man. Hey, yo, the next time we put the sign up, let's go, man. Like, it is hard, but it's so much fun, man. And we are actually debating against college students, man. Like, she about to be a teacher, man. Like this is where we at. Like, this is where we at. We're not down there. We here. You understand what I'm saying to y'all, brothers, man? We intellectuals too. Let's get it, man. I encourage all y'all dudes to sign up next time. And I actually want to see y'all up here closing, putting the work in, man. Let's go. Thank you.
Good evening, John, Brittany, Lieutenant Brass, everybody that had a hand in making this possible. I really appreciate it. For me, as one of the previous winners of the NPDL National Prison Debate League, I would like to welcome and congratulate everybody that has joined and has decided to participate. For me, intellectual discourse is very important, no matter the subject. We get to learn about each other and realize that we're a community, whether we're inside or outside. But as I look around and I see all the faces in here, this subject is very near and dear to my heart and all our hearts, because thinking about bail reform, I'm sure all of us here can understand that a system that is designed to tilt the scales on the side of the wealthy is tantamount to ransom. The 5th, 6th, and 14th Amendment supports the idea of innocent until proven guilty. And that is the presumption of innocence. And a lot of us fell victim to such a system. So I would just like you to consider these things. I really don't have to remind the people that are here, but for all our friends and families that are outside, when policies and laws and things appear and they just seem faceless and like numbers, understand that these things are connected to people. With that said, I appreciate to be here for the second time. Wish everybody a happy and safe journey home. Thank you.
Thank
Can
you.
I say
Very
one
well
thing?
said. Well, I would, yeah, in a moment, I was going to say, I know Rita's ready to announce the winner. So I was going to start to segue into that, but please, yeah, if you want to make some remarks to the teams before we announce, feel free.
Yeah, thank you. I just want to just say I'm very impressed with all of you. This was a really incredible debate to watch. And thank you so much. I thought that was just an excellent job by everyone.
Thank you so much, Dom, and it's great to have you. Again, the National Prison Debate League is something that continues to expand organically from the inside out because it was created from the inside out. And I definitely want to just take a moment and reiterate one of the things that all of our members from the Cheshire and T.R.U.E community just echoed themselves. But that is just the respect to Binghamton, because it's not just about the academic discourse that was noted and the skill level, which is off the charts from both teams. Totally impressive. I echo what Dom's saying and everyone else. But certainly, you're ambassadors of change now, of real what we call social diplomacy at the NPDL. And you are decarcerating minds because you take this unique experience home to your communities, and we start to have those conversations well beyond what you guys just started. So this was just the beginning of the conversation that will continue in living rooms all around the world tonight. So thank you for taking the initiative in breaking down these important social barriers, and elevating the conversation, because we shouldn't have debates and policies that exclude the people who are most disproportionately impacted by them, like many of these policies have been clearly illumined to do. So with that, I just want to thank certainly Binghamton, also adopting our format, which is unique from the college circuit. So with the 5-person teams, and we just really thank the accommodations and the courage and honestly the skill level, because yeah, the T.R.U.E team, I know some of you guys are new members, but thank you for trusting our process. Thank you for trusting our coaches. This was built from the inside out. We started this on the same stage where Malcolm X learned his public speaking and debate skills in Norfolk State Prison. And we're not going to stop until it's accessible to every man, woman, and young person who can access our programming. And we want to thank all of you for helping sustain it. With that said, your Chief Judge, Rita Rosenthal, is here to announce the winner of today's debate, although there are certainly no losers from this particular community that we're building. So thank you all. Rita, the floor is yours.
Just to reiterate what everyone has said, the logic and use of evidence I thought was amazing. And we do have a winner. The winning score was 220 points to 189 points. And the winning team is the Binghamton Prison debaters.
Rita, is it Binghamton won or the Cheshire team won? The T.R.U.E team?
The prison team.
Oh, so the T.R.U.E debaters from Cheshire won the debate?
Right.
All right, congratulations. Congratulations. Thank you both. Anybody want to say a final word as you hoist the hardware?
I'm learning from you. Across it.
Brittany, do you want to?
Oh, thank you.
Close us out? We're good?
I lost control.
It's all good. Have a great night, everybody. Thanks for tuning in. Stay tuned to the website for our next event. Thank you so much.